Hi, Bill Henshaw here again, your friendly local constitutional kook. More current events. And here's one that really underscores the problem we have in the system, and that the Florida Supreme Court had just issued a ruling taking a ballot initiative off the ballot to change the Florida Constitution because they claim that there isn't any authority for the voters to do it. What the hell is this? I mean, that's one thing we have a right to do, and even all current state constitutions, quote unquote, say this, but we have a right to change the government, basically at our will. And often it does happen with ballot initiatives, especially out here in California. Of course, the problem with all that is with the current constitutions in effect, really, we can't make much in the way of differences, even if it looks like it. For those states admitted into this union, of which California and Florida both qualify, except for the fact that this union has been out of existence for 160 years, then we can make changes like that. And think about the relationship here. I mean, my goodness, the lawful de jure, just sanguinis, free white state citizens ordained and established this Constitution to secure the blessings of liberty to ourselves and our posterity. My goodness. And if that's the case, and we created all other government for the same purposes as well, simple deduction. If that's true, it makes the relationship of the members of the sovereign body politic and their government agents its principal and agent. We tell them what to do, not the other way around. And here you have the Florida Supreme Court, who are agents of our agents, saying that. The basic problem from my perspective is that all these damn idiots on the Florida Supreme Court and all these quote unquote courts these days are required to be state bar association attorneys. Like a lot of things, it looks good on paper, law school graduates, this, that, and the other. Ultimately, it's all bullshit. It just doesn't work that way. Number one. Number two, if we had the Republican form of government that we should have in states guaranteed by Article 4, Section 4, and those of you out there, look it up and see how many cases you can find that the 9 parts have ruled on that case. I'd love to hear it. Article 4, Section 4, Republican form of government. Among other things, in a Republican form of government, it means that any member of the sovereign body politic is qualified to hold any office in government. Any, A-N-Y. Doesn't matter, whether it's a judge, attorney, whatever. And in fact, we're better off if we do it ourselves, because what they're teaching in law schools these days, there's no clue. Starboard, Bale, UC, Berserkly, your Alan Dershowitz types, they either don't have a clue or they're carefully concealing the truth so that people like us, everyday Joe Sixpacks, don't know it. Now, that's a major argument, by the way, that defeats any agency of the de facto government across the board. Because without that Republican form of government, and you go into their courts, and I've got 5 decades worth of documented evidence, which is what backs you up when we get around to going on the offensive, in your case, relevant, admissible material that says they're not going to listen to it, even if it's unopposed, and it always has been. I have never had any of my documents opposed. And what do I have? And what do you get in my constitutional defense document packets? 41-page motion to dismiss, 25 pages on the 14th Amendment, 84 pages on no states. To learn more about that, send me an email, youwinincourt@gmail.com. I'll get you the information out. And you see this stuff. And if I'm making claims like this, and if you're making a claim that there are no states, you had better understand what the hell it is you're doing. And what I tell people is you get my documents and study them a little bit. You won't have to put in 10,000 hours in those musty old law books like I did in the law libraries. But you go in there in the court and you say it, with attitude and with authority. And you don't have to be near as good as I am, but you do that, and it sets them back, and it damn well should, because the bottom line is what we're really saying is if we're in a court without jurisdiction, then all of your official actors are personally liable. You've committed acts of treason to the Constitution. That's not me saying it, by the way. Not only is that the U.S. Supreme Court, that's Chief Justice John Marshall, that infallible icon of Harvard and Yale, who was never wrong, was he? Treason. I mean, they're bound by oath by this Constitution and the laws enacted in pursuance thereof. Why the hell aren't they doing it these days? And they haven't been, in part of my personal view, for close to 160 years. That's what has to change. And we can get it done. But we have to do it the right way. And, with all this nonsense with the part of the Supreme Court saying to the people of Florida that you're incompetent to make changes in your own Constitution, then I got a question for you bastards on that court and all the courts across the country. How is it on the one hand that we're incompetent to change the Constitution, and yet we're somehow competent to have formed the criminal intent to commit the crime? Which way is it? And what does that say about our competence one way or the other on election day? That takes all these elections out of the sequence. There are no elections. There is no consent of the governed. There is no government. Simple once you understand the right perspective. And the Florida Supreme Court has given us all a big boost there in doing what they've just done and telling their principals that they're incompetent. So if we're incompetent, we must have also been incompetent when we ordained and established this Constitution and all government. Damn. I mean, it's not hard when you think about it, but the problem is you don't learn anything in the 12 years you're in the mandatory public education system that teaches you things like this. Wasn't always true. I have my grandmother's hand-me-down books from her days when she was in school around the turn of the century. These were late 19th century, Appleton's fourth, Swinton's fifth, McGuffey's sixth readers, and you read these, and they're what you would recognize today as college textbooks, and maybe even better than that, since most colleges don't teach a lot, especially in these areas either. But people knew, they learned, and when they got on juries, they knew basically what to do, much more so than juries do now. Juries don't have a clue. They can rule on the facts and the law. Yet the Constitution mandates it, the Supreme Court recognizes it, and this right goes as far back as the Magna Carta in 1215. And yet we had the 904 sanctimoniously saying that there's no right to trial by jury in any criminal misdemeanor case. They really said that. Blanton v. Nevada, 489 U.S. 537. Send me an email, youwinnincourt@gmail.com. I'll get you a copy of that decision. And oh, by the way, they strongly inferred that there's probably no right to trial by jury in a felony case either. They've not overtly made that ruling, but trust me, there's precedent for it. That's another thing you'll learn by getting my materials. There is precedent for that. You don't need a trial by jury. See you later. All you need is an administrative hearing. And oh, by the way, the 904s, once again, Enox v. Williams, 370 U.S. 1, have ruled that a taxpayer, quote unquote, which you're not if you don't have a social insecurity number, can be taxed out of existence without any apparent need for even an administrative hearing, let alone a judicial trial. How the fuck does that happen? Well, you learn all about that getting my materials, exactly how this has come to be, and learn how to fight these bastards and beat them at their own game. That's the beauty of it. Doing what I did in South Carolina, I shut them up in 30 seconds, stunned them into silence. A video I would love to have, $1 million video. They claimed not to have made a copy of it, conveniently claimed not to have made a copy. This in a court of record, right? Not there. You should have seen the looks on their faces. I've never seen anything like it before or since, but it tells us the power that we still have. It's there. You just have to know it and be able to go in court and do it. And that's what I teach you how to do. And I'll be with you every step of the way. You get with my materials, complimentary phone consultations, a lot of email backup, and even a Zoom appearance at a contested hearing. That makes it all the easier. But you go in and start talking like this, and then the good news is that they're so colossally ignorant on the other side, they won't know that you're not as good as I am. they're going to know that they're in big trouble, because these are laws that they maybe don't even know. And that's why, by the way, these black robe bastards in particular get condescending with you, dismissive, derisive, because they don't know the law and they don't want you to know that they don't know. I mean, that's not much of a job qualification for that job, is it? Wow. So it's just amazing. It really is. But this is what, gives me life, gives me my function. I'll be 73 later this year. Life is still ahead of me. And this is why I was put here, to make a difference. Would have been nice to have known that 50 years ago, but at least better late than never. And I put in the time, I've done the work, I have the portfolio, and I can help you do it too. That's the great part about all this. So remember, we have to all work together across the board. Americans, Africans, and Asians, cut out this divide and conquer crap, and we can do it. That said, remember to like the videos, subscribe, tell your friends, get the word out. We can beat these bastards. Thank you.